Good morning, friends. In my series on the income tax cases, the case which I am going to discuss today is Vision Mines and Minerals Private Limited versus Income Tax Officer. This case has been reported in 96 ITR, short notes page number 51, and this matter has been decided by Honorable Raipur ITAT. And the case is very recent. The date of the judgment is 27th May 2022. Friends, in this case, a very peculiar situation came before the Raipur ITAT. The addition of the assessee was made by the assessing officer under section 68 in the year in which the shares were allotted. The consideration for which these shares were allotted has been received by the assessee in the previous years and not in the year in which the addition has been made. The assessing officer was making the addition under section 68 on the plea that the assessee is not able to prove the identity, credit, worthiness and genuineness of the transaction under section 68, and the plea of the assessee was that apart from submitting all the documents which were necessary for section 68, assessee was saying that section 68 can be applied only in the year in which the money has been received, in which the credit is there in the books of accounts, and the credit is not there in the year in which the addition has been made. The credit has been received in the previous years. But the assessing officer was not convinced with the assessee and made the addition under section 68. The assessee went into the appeal to the CIT appeal, and the CIT appeal was also not convinced with the version of the assessee, and CIT appeal upheld the order of the assessing officer sustaining the additions made by the assessing officer. The aggrieved assessee has no option left except going to the ITAT, but the ITAT appreciated the facts of the case, appreciated the integrities of section 68 and held that the addition made by the assessing officer in the year in which the credit has not been received by the assessee is not sustainable under section 68. Because the year in which the addition has been made, the assessee has not received any money for which the addition has been made, only the allotment has been done. So the allotment does not entitle the assessing officer to make the addition under section 68. The ITAT also said that if you wish to make the addition under section 68, then you have to reopen the case under section 148 if the time limits under section 149 permits, and then you can make the addition as per the law for the year in which the share application money has been received by the assessee. This is a very welcome judgment by the ITAT, and we have seen that in the very old times the share application money was received, it was kept by the assessee, and the allotment was done after so many years. But nowadays these type of issues are not coming, because the reason is that the Companies Act says that you have to allot the shares in 60 days. But it may happen that the cases are pending for the various years in which the share application money has not been received in the year of the allotment, but the addition has been made in the year of the allotment. So this case is very important in dealing section 68 cases, especially when the addition has been made not in the year in which the share application money has been received, but in the year in which the shares have been allotted. Friends, sometimes it happens that we fight the case on the merits. On the merits we may be a little bit weak, but if we will read the section and if we know the case laws on the topic directly, then we can win our case. Because sometimes when we know the law but our knowledge is not backed up by the proper case laws, then we are not able to present our case very efficiently. So this case particularly helps in those cases in which the credit has not been received in the same year, but the addition has been made by the assessing officer by saying that you have done the allotment, the share capital account has been credited, but the money has not been received because the money has been received in the previous years. So in this case, the ITAT deleted the addition made by the assessing officer and gave relief to the assessee. This is a very welcome judgment. At the end of this video, I am once again repeating the name of the case. The name of the case is Vision Mines and Minerals Private Limited versus Income Tax Officer. Friends, at the end of this video, I appeal to you, if you feel my videos are important, my videos are worth hearing you, then you can subscribe my channel and press the bell icon so that you may receive the future notifications. And we are attaching also the copy of the case laws for your reference and short notes so that you may get a quick reference. Thank you, friends.